Justice Pratibha Singh, Mr. Naidu, all the senior advocates and the lawyers from the Delhi High Court, the organizers of today's event, Law Forum, very, very good evening. I'm going to try and keep it as brief as I can, but this is one of my favorite topics, so I don't know how to do that. So, Commercial Courts Act, we've seen the journey of this act since the time the legislation got drafted, actually. I remember we even went to I'd even gone before the parliamentary committee to whom the bill was referred to, and one of the questions that was asked in the parliamentary committee by one parliamentarian was, why do we need commercial courts when people are languishing in jails? So it was a very, very pertinent question and put us to thought even at that time. So the answer which one of the experts there who was there gave was, if you have separate courts for commercial law, it's better that all the other courts take care of the criminal cases and their dedicated benches, rather than having, precedents for commercial courts cases in all courts. That used to happen before. But now I think that it's pretty streamlined. We have our own commercial courts for commercial cases and the criminal courts for the criminal cases, the tax court for the tax case, the arbitration court for the arbitration cases, and it is helping that each of these cases get their own precedents in their courts. So that way each one is not trampling on the other. So as far as my own experience in the commercial courts legislation is concerned, I must say that my experience has been extremely good. In the last 10 years, it's been 10 years since we've had the commercial division and the commercial courts in Delhi. So how many of the lawyers here go to the commercial court in the district court? Can you just raise your hand? Okay. Next question. How many lawyers feel that the experience in the commercial court is between 7 to 10 on a scale of 1 to 10? How many of you feel it's between 4 to 7 on a scale of 10? So the remaining feel, I would say it's about 30 to 40% feel it's on a scale of 7 to 10. I'll just give a few examples of how case management and Order 15A and summary judgment is being used. My own experience now in the division benches, every week we get about 4 or 5 appellate cases which are from the commercial courts, and at least 3 of them are Order 13A decrees, which is a very good statistic of use of summary judgments. Almost all the suits for recovery which are coming, where the defense hardly has a prospect of, defendant has hardly got a prospect of winning, in fact is decree. And yesterday or day before I saw one case where the plaintiff didn't have a prospect of a decree, and so under 13A the suit got dismissed. So it actually shows that this is making a difference on the ground. Would you all know how many commercial court suits are filed every year in Delhi? In Delhi, all the commercial courts. 49 commercial courts. There are 22,000 commercial suits filed every year in Delhi. And would you know the disposal figures? 21,500. Justice Hema Kohli, she was the judge in charge of the original assignment. So I was sitting in the court, I was still a lawyer, and it was one of the early times when the Commercial Court Act was enacted, and the defendant in a trademark matter kept saying it was for framing of issues, and the defendant said, this court doesn't have jurisdiction, please frame an issue on that matter. So the plaintiff kept fighting and the defendant kept fighting 5 minutes, and then the honorable judge then said, okay, we'll frame the issue. So the judge dictated the issue and then said, if this issue is decided against the defendant has to pay 1 lakh cost to the plaintiff. Immediately, the defendant's lawyer withdrew that issue because he knew that because the defendant was selling in Delhi, there was no way he could win that issue. So case management is helping a lot. Let's take another case. Again, an IPR matter where the plaintiff came up with a list of witnesses of 80 witnesses. 80. In a case where there was an injunction, interim injunction. And the defendant was fighting hard, saying, I want the trial to go on, I want the injunction vacated. So the judge asked, why do you need 80 witnesses? He said, I want to prove each of the invoices which is there in the suit, with the person who's received the invoice. So the judge then said, okay, why do you need to do that? You can have one plaintiff prove all the 18 witnesses, 80 invoices. So from 70 to 80 witnesses, the list of witnesses were cut short to 4 witnesses. So this was very unusual under the CPC regime. And I would agree with Justice Pratibha Singh that the earlier CPC did give us the power as judges to do all this, but most of the times we got caught in the quagmire of procedure, and we would not be able to do it because the judge did not have the discretion, which was so clearly spelled out. So what Justice Singh said is absolutely correct, that the experience of judges was completely streamlined into the Commercial Court Act, which is a legislation which is this thing, unlike the CPC of 1908. So I want to give another illustration. There's a good friend called Lord Justice Colin Burns. He's a judge of the Court of Appeal in the UK. So when I visited him about 1.5 years ago, and in his chamber in the Court of Appeal, he had the white book of CPC, which is the UK Code of Civil Procedure. So, and I was very frank and I said, look, Colin, I don't know how you work with your CPC, because you gave us this colonial CPC of 1908, which we still strive and struggle to get our civil cases done. So he then pulled out the white book and he said, just read section 1 of the UK CPC. He said, we don't go beyond section 1. And section 1 of the UK CPC said, despite all this procedure, the court has the power to consider the following factors to meet the ends of justice. And one of the factors was the resource of the court. How much resource of the court a case is going to occupy. The judge can look at that, think of that, and then decide how much time is being given to the case. So section 1 of CPC UK, any one of you could Google it, you could read it, you will realize that they have moved on much beyond the 150 years that we thought of. Have you ever compared it, Mr. Chandrachud, Mr. Jain, Mr. Banerjee, I'm sure all of you are ready. If you ever compare it with the Commercial Courts Act, a lot of the principles in the Delhi High Court Original Side Rules, which we amended in 2018, almost 50 years after the first set of rules were made, are incorporation of the Commercial Court Act principles in the CPC, in the normal non-commercial litigation. So in the Delhi High Court, even if it's a partition suit today, it would be mandatory to stick to the timelines of the written statement. And that has really helped our commercial division shape even non-commercial suits in a very efficient manner. The only bottleneck, of course, is the quantum. We have lesser judges on the original side. When we used to have 9 to 10 judges on the original side, obviously the efficiency was much more. But using of the Commercial Courts Act has been extremely beneficial for commercial litigation. And you know, from the statistics that is available on the National Judicial Data Grid, one commercial suit in the Delhi district courts, the average time taken is less than 2 years for the degree. Average, we're talking about average. It could be anything between 6 months to 18 months, but now it is around 18 months average. And the other problem of execution, which both Justice Gupta, Justice Singh, everybody, and Mr. Naidu have highlighted, on execution, the average time taken could be anything between 40 to 50 days till about 150 to 200 days in the Delhi commercial courts. So, both in terms of decrees being passed and in terms of execution, our commercial courts are doing exceedingly well. But I do agree that Delhi is a very privileged city and Delhi is a very privileged court. But yes, at least we have started the process. And now coming to my own favorite, intellectual property division, which forms part of the commercial court division, I can tell you on an annual basis, the IP division is actually having more disposals than filings, despite the large number of cases that were transferred from the intellectual property appellate board to our court. 80% of the transferred cases have been disposed of within the last 4 years, and right now our IP division is beating the filing by about 50 matters in a year. So the filing, so these things show that having specialized benches, specialized courts, dedicated divisions is really helping. And I would think the best way to go forward as a country, see, every commercial dispute or IP dispute or arbitration dispute, the number increases as the economy grows. And as we see more and more urban areas are coming up, semi-urban areas, tier 2 cities, we need to have commercial divisions, commercial courts in all these cities, even if it means for the first 6 months, the judge is having only sitting half a day, but he's writing judgments in the next remaining half of the day. This is the only way we can actually make our system more efficient. And I do believe that now Karnataka High Court has enacted, I'm not sure if it says a law, I think it's a law. They checked up with Delhi and then they have streamlined their original side rules like what we have. So it is, the movement is happening. Madras High Court, Calcutta High Court, Himachal High Court have dedicated IP divisions now. They have proper rules which have been framed. Most rosters in the country now, in most high courts, have IPR and commercial in their roster, which is mentioned. It may not be dedicated, but still, as the litigation grows, it is good to have dedicated divisions and dedicated courts. And of course, as with most enactments, when we have the Negotiable Instruments Act, we didn't increase the judges' strength. Even with the Domestic Violence Act or the Senior Citizens Maintenance Act, judges' strength definitely needs to be increased. There needs to be more budgetary allocation for court infrastructure and courts. And I have no doubt in my mind that even if we take Delhi as an example, it is a good example to showcase and to see that having dedicated courts has really helped. And the Commercial Courts Act of 2015 has done a big service for commercial disputes. And I'll end with one last anecdote. There was a case sometime 3-4 years ago. In the summer vacation, the Supreme Court directed a day-to-day trial in a patent matter. And the cross-examining senior counsel was one of the most well-known senior counsels in the Delhi High Court in civil law. But the difficulty was the cross-examination wasn't concluding. The witness was from abroad. He was already here for 3 days and he had to leave in the next 1.5 days. So during vacations, we moved to court, and it was a judge who was really, Justice Edlock. He was the vacation bench. We moved an IA saying the cross-examination is not getting over. We don't know what to do because this is a foreign witness and he has to travel. So Justice Edlock then said, okay, cross-examination, 2 witnesses, tomorrow 6 hours each, one on Thursday, one on Friday. That's it. He exercised the Commercial Courts Act provision and he restricted the time. And believe you me, the cross-examination got over. So it just shows that the provisions of the Commercial Courts Act can be used in the most efficient manner to make justice dispensation in this area of law extremely efficient and good for the litigant. Thank you. Thank you.